People of the State of Michigan versus Justin Jermaine Smith. It's file 19-5888FC. We have Mr. Jermaine Smith present with us in the courtroom, along with his attorney, Mr. Gilbert, and the prosecuting attorney, Ms. Goodrich. Department of Corrections Agent Dudek is appearing on Zoom video, and we are providing public access online. And Ms. Goodrich, I do see NMCAC in the waiting room. I believe that would be a witness for we continued this for an evidentiary hearing on a guideline score. And I was advised by counsel before coming on the record that objection is going to be withdrawn. Is that correct?
It is, Your Honor. I talked with my client. And we wish to withdraw the objection. It should be noted that my addition abilities, maybe my former life as a CPA, did not pay off last week. I added incorrectly, so we don't. The objection does not affect the scoring. The scoring is correct, and even if we were to gain those points, we don't change in the grid. With that being said, my client is withdrawing his objection.
Okay. Wow, I'm not going to fault you for that, because I would have thought too, taking 25 points away would change the grid, but it doesn't on this grid.
It doesn't. VOVs are
gotcha, 16. Gotcha. Okay. All right. So, Ms. Goodrich, do you want me to bring that person in so we can tell them?
Yes.
All right. Good afternoon. I apologize for the delay, and can you hear me?
Yes.
Okay, and I was just informed by the attorneys that the matter that was requiring your testimony no longer requires your testimony.
Okay.
All right, so I'm sorry. I'm not sure that, well, I'll apologize for the delay, but not for telling you not to testify, because you probably don't feel too badly about that. Okay,
no,
but
not a problem at all.
And, okay, you have a good day.
All right, thank you.
All right, so we're here for sentencing then. Let's go ahead and start afresh then. Mr. Jermaine Smith, we're here for sentencing on a charge of criminal sexual conduct in the 4th degree. That is a high court misdemeanor, punishable by up to 2 years in the state prison. Have you had a chance to review the pre-sentence report and recommendations with Mr. Gilbert?
Yes, I have, Your Honor.
All right, Mr. Gilbert, do you have any additions or corrections to the factual information contained in that report?
We do not, Your Honor.
Ms. Goodrich?
No, Your Honor.
The advisory guidelines are scored at 0 to 9 months. Mr. Gilbert, do you have any objection to the scoring of the guidelines?
I do not.
Ms. Goodrich?
Before we dive in, just a quick note. This commentary is created for educational purposes, designed to help those who may be confused or curious about courtroom processes. If you don't find it helpful, feel free to skip ahead. But for those who want a deeper understanding, stay tuned. It's about to get intense. At this point, sentencing appears straightforward. The guideline range is relatively low, the defense is emphasizing remorse and a clean criminal record, and the disputed scoring issue has already been withdrawn. But pay close attention. What happens next completely changes the tone of this hearing. The judge is about to confront statements that raise serious questions about accountability, credibility, and whether the defendant truly accepts responsibility for the crime. Do you think remorse alone should influence a sentence when the underlying allegations are this severe?
No, Your Honor.
All right, and Mr. Gilbert, anything you'd like to say on behalf of your client?
Your Honor, my client stands before you remorseful for his actions. He understands that he has done damage to another individual, even though the child is young, that this could emotionally scar the child. And as I said, he stands before you remorseful today. We'd ask the court to place a sentence within the guideline range. I will point out he has no prior criminal history. This is the first offense for him. And would ask the court to take that into consideration and score him sentence him within that guideline range. Thank you, Your Honor.
All right, thank you. Mr. Jermaine Smith, is there anything that you wish to say, sir?
I made a terrible mistake. I made a mistake.
Well, Mr. Jermaine Smith, you'll have to forgive me here for a minute, but I'm a little confused because at your plea taking, you told me on the record, I went and watched it again so I could know exactly what you said. This is a direct quotation from your plea taking. I pulled her, speaking of your 4-year-old niece, I pulled her onto my lap while I was sitting on the couch watching TV, and I removed her diaper, and I touched her vagina, but I did not penetrate. That was your statement under oath to this court. And then I read in the pre-sentence report that you hate that you had to say you did something when you don't really know if you did or not. You don't remember doing anything, maybe, but you just don't know for sure. You just took the plea since 2 years is better than 25, especially since you don't know if you really did it or not. And then today you give me some tears and say you made a mistake.
Because I'm pretty sure I did do it, Your Honor, even though I don't remember it from my concussions, from my time in school, from all the sports that I get times I just don't remember. And it's entirely possible that this happened in one of them. And if it did,
Well, which is it? Did you plead guilty because you are guilty?
I believe I am. I believe I did it, but I don't know 100% for sure. I believe I did.
Why did you give me such a detailed statement at your plea taking?
I just said what the police report said.
I mean, that sounds like somebody that's remembering some details. You talked about where you were seated, what you were doing, what you were watching. That doesn't sound like somebody who doesn't remember, Mr. Jermaine Smith.
I just said what the police report said because I knew that would be accepted, but I honestly do not remember doing anything. And if I did do something, I do deserve to sit those 2 years, but I don't remember doing anything.
This is one of the most critical moments in the entire proceeding. In criminal court, a guilty plea typically requires the defendant to clearly acknowledge the conduct that supports the charge. Here, the judge is struggling with conflicting statements. First, a detailed admission under oath, then later uncertainty about whether the act even happened. That inconsistency immediately raises red flags. Notice how the judge keeps pressing for clarity rather than moving straight to sentencing. From a courtroom perspective, credibility matters enormously, and shifting explanations can dramatically affect how remorse and responsibility are perceived. If you were the judge, would these explanations sound convincing, or would they create even more questions?
Well, so what am I to do with this? I mean, you're telling me today you don't remember doing anything. You think maybe you did it. I mean, do you want to have your trial?
No,
It's not my practice to take pleas from people who can't tell me that they did it.
I mean, I'll take the guilt. I'll say I did it. I believe I did it. I'm sure I did it. She wouldn't just be saying this if I didn't.
So now you're telling me you're sure you did it.
I'm sure I did it. I 100% believe I did it, even though I don't remember it. She wouldn't just be saying this. I know her. She wouldn't have just said this if nothing happened.
You're not going to jail today. You're going to go to prison today.
I know.
All right, Ms. Goodrich, anything from the people?
Yes, Your Honor, the victim's mother, Andrea Martin, wishes to speak.
Okay, Ms. Martin, you go ahead and sit down, Mr. Jermaine Smith. Ms. Martin, you want to come up to the podium? Go ahead and tell me anything that you think. Go ahead, take your time.
Okay. Okay, Your Honor, with a long, almost 3.5-year case of the victim's mother, I hope to engage a storm in you like the same storm that has hovered over my family for years now, with the words I am writing, in hopes of swaying you towards giving Justin Jermaine Smith the max. Every morning when I wake up, I think about my daughter and how the most purest thing she had was taken from her, her natural-born innocence. My daughter lost everything that day, we just didn't know it yet. She did what she was supposed to do, which was tell someone. The same family and person who greeted my daughter moments after birth, the same ones hurt her. My daughter went through so much more than most her age due to what Justin did to her. And due to such actions, she suffered from and or still suffers from regressed potty training at the time. Fear of new and previous men being around her, meaning her doctors, friends, my coworkers. Distrust, she went to me for help and lost everything. Nightmares, which are still ongoing, and then decline in academics, the first 3 years of her schooling. And touching her siblings in inappropriate manners, which thankfully due to counseling, this has declined. She also touched her dolls inappropriately for a long time while laying in bed. And finally, she's promiscuous. My 7-year-old daughter is promiscuous because something so innocent was sparked in her. And she also needs constant reassurance that she is enough and she will be okay. The same family and only family my daughter knew, as I don't have family in Michigan, shunned us. Here sat my 3.5-year-old daughter at the time with zero understanding of why. And here she sits at almost 8 years old, still wondering why. Why would Uncle Justin, Nana, and Papa ever do such a thing to me? For years, we have lived a life of weekly counseling with many different counselors, trying to help heal my daughter. We have lived a life where, as a parent, this couldn't be kept a secret. We had to tell teachers, coworkers, doctors, and bosses. Do you know how many jobs I lost over the years because of court, rape center interviews, and weekly, sometimes twice a week counseling? I've had to beg and plead with my bosses. I've lost 3 jobs over the years due to this case, begging and pleading because my daughter was molested by her uncle, not even in my care. As a parent, do you know how shameful that was? Taking points and write-ups with tears in my own eyes because I needed to take care of my daughter. I was doing this all alone with no support system. Throughout the years, I have been asked to write on forms for restitution or for mileage coverage. Even when needed at times, I never lifted a pen for those pages because no dollar amount will give my daughter back her innocence. I pray with all my being as a person, as a mother, that Justin is sentenced with the maximum that is allowed. While he may only get a small fine or a year or so in jail, my daughter will live with this for the rest of her life. This will resurface with her first boyfriend. It will haunt her in moments of happiness. This won't be a closed book. It will be a closed chapter. We will heal, no matter what, like we have through these years. On the hard days, I have said to my daughter, we are strong because we are fighters, and that's just what we are. I pray that you find it in your heart to sentence Justin Jermaine Smith with the max so we can close this chapter. We are ready to just be strong and no longer fighters. And that's all I have.
Thank you, ma'am. Ms. Goodrich, any recommendations from the people?
Your Honor, in addition to Ms. Martin's statements, I just ask the court to take into consideration the defendant's lack of accountability for his actions, the lack of remorse, and that the focus in his PSI interview was more on himself than how this has impacted his niece. I'd also ask the court to continue the no contact with the victim. Thank you.
All right, Mr. Jermaine Smith, you want to rise for the sentence of the court? Yes, I just want to confirm for this record then, Ms. Goodrich, do you believe there's a sufficient factual basis to support this plea?
I do, and for the reason also as stated in the PSI.
Mr. Gilbert, do you believe there's a sufficient factual basis to support the plea?
I do, Your Honor.
And Mr. Jermaine Smith, are you being sentenced today for criminal sexual conduct in the 4th degree because you're guilty of that crime?
Yes. I believe I am, yes.
All right. Well, Mr. Jermaine Smith, that crime carries with it a maximum penalty of 2 years in prison. This court doesn't choose the charges. It doesn't choose the plea bargain. It's no surprise to defense counsel and the prosecutor that I think it's a terrible outcome. There's nothing I can do today that's going to be sufficient to respond to what you've done. All I can do is what I'm allowed to in the law. And what I'm allowed to in the law is there's a maximum of 2 years. And we have indeterminate sentencing in Michigan, so I have to determine what the minimum sentence is. The advisory guidelines range is 0 to 9 months. That guidelines range does not take into account the gravity of this situation. You removed another human being's diaper to sexually assault that human being. You did engage in sexual penetration with that child, which would require a mandatory minimum in prison of 25 years. That's what you deserve today. The law says that's what the response is to somebody who sexually penetrates. If you're 17 years of age and you sexually penetrate somebody under 13, a 12-year-old, the law says 25 years in prison minimum. That's what the law requires. You sexually penetrated a 4-year-old who was your niece, and I can give you only a fraction of that, and it's a crying shame today. But I can't follow those guidelines. They don't even come close to touching the severity of what you've done. The law says that in determining the minimum, I can only set it at 2/3 of the maximum. Otherwise, we don't have indeterminate sentencing. The parole board has no area of jurisdiction. So the very most that I can sentence you to by law from the plea-based outcome that's been handed to me is 16 months in the state prison. I can only give that if I find that your case is among the worst CSC 4th cases. I find that it is. CSC 4th is sexual contact without consent. This was, you engaged in sexual contact and penetration with a 4-year-old who was your niece. And you're still hedging on whether to take responsibility for it. You tell me under oath what you did in detail. Then when you're in front of the pre-sentence investigator, you try to hedge your bets and say you're not sure you did it. Then you come here today and give me crocodile tears and for sympathy or something, I don't know. And then you're telling me, yeah, you're sure you did it. I'm sure you did it. But you have taken no responsibility for it, no real responsibility for it. You have no real remorse for it. You've never shown any in this case, not even today. Nobody's fooled by those tears, Mr. Jermaine Smith. So I do believe you are among the very worst of criminal sexual conduct 4th-degree offenders that I have ever encountered in my 20 years of practice. So I will do the maximum that the law allows me to do. So I will commit you to the Michigan Department of Corrections for a term of not less than 16 months, nor more than 24 months. You'll have credit for, let's see, it's 52 days plus from last Tuesday to now is what, another 7 days, Agent Dudek?
That's correct, Your Honor.
All right, so you have credit for 59 days previously served. There's mandatory state costs of $68, crime victims assessment of $130, DNA fee of $60, court costs of $350. And just so that I can do every last drop of what I can do, I am going to assess a fine. The maximum fine is $500. I'm going to assess that fine.
This case ended with a sentence of 16 to 24 months in prison. The maximum sentence the judge determined could legally be imposed under the plea-based outcome before the court. Throughout the hearing, the judge repeatedly emphasized the seriousness of the offense, expressed frustration with the limitations of the charge and sentencing structure, and concluded that the defendant had not demonstrated genuine accountability or remorse. The victim impact statement also highlighted the long-term emotional and personal consequences described by the child's mother, underscoring how criminal cases can affect families for years after the original incident. Ultimately, this hearing serves as a powerful example of how plea agreements, sentencing guidelines, victim testimony, and judicial discretion can intersect in complex and emotionally charged ways. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
This is a departure from the guidelines, and I have explained both the basis for the departure and the extent thereof. So that's the sentence of the court. And Mr. Jermaine Smith, you are able, if you wish, to file an application for leave to appeal to the Michigan Court of Appeals to challenge your conviction or my sentence. If you can't afford an attorney, we would appoint one for you at public expense, but you would have to make that request within 42 days of today's date. Or if you knew that's what you wanted to do, we'd give you a chance to fill it out even here in the courtroom. One copy of those appeal rights is for you to fill out or for you to initial so that we know that you have it. And the other one is for you to fill out if you wish to appeal. Do you have any questions about that, sir? All right.